Again, my name is Martin. I'm from ITM Münster, and I want to talk to you about legal aspects of digital preservation. So we want to focus on copyright issues and digital preservation. So when we talk about copyright of digital preservation, we first have to have a brief understanding how copyrights work. So first of all, the basic concept of copyright, we always ask ourselves, is there something protected by copyright? Is there a book? Is there a digital picture? Is there a computer program? Is this something we want to preserve? Is this protected by copyright? And if we say yes, this is protected by copyright, and the moment we say yes, then we already know that when this something was created, in this moment, the author of this something gained exclusive moral and exploitation rights. So he gained moral rights, saying moral rights that protect his non-material interests. For example, moral rights are the right that everybody accepts you as the real author, or a moral right can be the right that you decide as an author when you, for the first time, publish your work. So these are moral rights, protect the non-material interest, and exploitation rights protect the material interest. These rights are the rights we will focus on today. For example, reproduction right, alteration right, so everything you can make money out of. So we know something is covered by copyright, and we know that in this moment when something was created that is covered by copyright, then the author gained exclusive right. There's nothing like I need a copyright stamp on my work. There's at least in the European Union. Or nothing like I have to apply to get the copyright. So he automatically gains these rights. And in a last step, we always ask ourselves, okay, we have an exploitation, we have some exclusive rights, and maybe we have an infringement of these rights. And if we have an infringement of these rights, we could ask ourselves, okay, is this infringement of the rights still okay because we have something like a limited, something like an exception or a limitation of this concrete, let's say, exploitation right, and then we are still allowed to do whatever we want to do. So this is something like the basic concept of how copyrights work. Today we will focus on the European directives on copyright, especially on the Information Society Directive and on the Computer Program Directive, because they are very, very relevant for us. I want to make one thing very sure. When I today talk about reproduction rights and alteration rights and an infringement of alteration rights, which come from, let's say, Article 2 of the Information Society Directive and so on, then you always have to be aware of that when you go home to your countries. You can't look in the directive itself. The directive has no direct impact on your legal system, but only the national implementation of this directive has a direct impact. So you always have to look up stuff in your national copyright law, but I promise you, you find all this relevant information we will talk about today in your national copyright law. So, object of protection and relevant exclusive rights. So what is protected by the Information Society Directive and what is protected by the Computer Program Directive? First of all, the Information Society Directive. It's something like the copyright directive for digital artifacts. So everything that is not a computer program is covered somehow by the Information Society Directive. Especially this Information Society Directive provides authors with exclusive rights regarding their works. This is the copyright. And then this Information Society Directive also provides performers with exclusive rights regarding the fixations of their performance, and phonogram producers and producers of films and even broadcasting stations. These we won't focus on this for smaller rights because we will focus today on the real copyright and none of the what's called related right. The related rights are something like a small copyright which only focus on material interests. And on the other hand, you have the Computer Program Directive. And of course, the name says it, the Computer Program Directive covers everything regarding the protection of computer programs. One question, maybe it's kind of stupid, but what is a computer program? Anybody? What is a computer program? My problem is, as a lawyer, I have no definition from a legal point of view what a computer program is. You know, the recital 7 of this directive, of the Computer Program Directive, says, when you implement this regulation in your national law, please implement, your implementation shall include programs in any form, including those which are incorporated in hardware, and also include preparatory design work. So this is all covered by the term by the term computer program. But the directive, it says, does not define the term computer program. But this was a conscious decision of the European legislator, because why? Anybody, some idea why? Why? It would be perfect. Yeah.
Because the nature of what's a computer program will change over time.
Yeah. That's exactly the point. And it would change too fast. It would be outdated very, very quickly. And it takes years till a new directive, till they create a new directive. So it's much easier to leave this term open and leave it to your national courts and some other organizations that or scholars that can very quickly react on new actions, on new developments, and include, if you wanted, include something new into the term computer program. So far, object of protection. What is protected? So this was the first step of my three-point step. Basic concept of copyrights. We're now on the second step of this basic concept. We ask ourselves, okay, now we have something that is covered by copyrights. Which rights may be infringed, or which rights does the creator have? So both directives give nearly the same rights. So the Information Society Directive has a reproduction right and the right of making available to the public, and a distribution right. And of course, the Computer Program Directive has something like the same. It's the reproduction right, the alteration right, and the distribution right. But for digital preservation, only the reproduction right and the alteration right is relevant for the legal analysis of the DP actions. So we will focus on the reproduction and the alteration right. First of all, the reproduction right. The directive, the Information Society Directive, so the one not talking about computer programs, defines the reproduction right as the exclusive right to authorize or prohibit direct or indirect, temporary or permanent reproductions by any means and in any form, in whole or in part, for authors and their works. This is an incredible broad definition. Why? It covers even indirect, temporary reproductions in any form and in part. So I can understand indirect. I mean, when I have a CD or some music on vinyl, gets cool again, and I make a copy of that, I can only listen to the music when I put the CD in my CD player. So it's an indirect copy of the music. I need something to listen to the music. That's indirect. If I copy a book by making a new print, it's a direct copy. I can directly see what I copied. So even indirect copy is covered. Got that. Even if you copy only a part of the copyright protected material, it's covered. So if you only copy a small part of a picture, you all know from the Sistine Chapel, these two angels. So this is only a part of the picture, but it's still copyright protected. In any form. So I don't care if If I make a copy, let's say from if I change the format, let's say from my CD to an MP3 to listen on my iPod or something. So this is covered too, and also, and this is why this definition is so incredibly broad, it also covers temporally reproduction. So why is temporally reproduction in any way interesting for digital long-term preservation? Because think about any action you can do with a digital file. Let's say you have a JPEG. You double-click the JPEG. The JPEG, it's reproduced in the RAM, somehow reproduced in the graphic storage, somehow reproduced on your screen. So these are 3 reproductions, and they're all covered by copyright law. And this is why this makes it so incredibly broad. It's impossible to act somehow with digital information and not touch this reproduction right. Very, very broad definition and very relevant for digital preservation. Also, we have this reproduction right in the Computer Program Directive. It's very, very similar to the reproduction right of Article 2 from the other directives. So it also says permanent temporary reproduction of a computer program by any means and in any form, in whole and in part. So somehow, like to prove that I'm not kidding, the legislator also wrote in the Computer Program Directive that he really is talking about what I'm talking about when I say reproduction in the RAM. He really said, insofar as loading, displaying, running, transmission, storage of a computer program necessitates such reproduction, such acts shall be subject to the authorization of the writer. So the legislator really wants that this is covered by the exclusive rights of the right holder somehow. And the Computer Program Directive also says that the alteration of a program is a restricted act. Alteration means the translation, the adaptation, the arrangement, or any other alteration of a computer program. So as a result, error correction, maintenance of the computer program is covered by the exclusive right and needs authorization if we not have something like a limitation or an exception. We come later to so maybe you recognize that we have an alteration right and a reproduction right within the Computer Program Directive, but I only talked about a reproduction right in the Information Society Directive. Of course, you are not allowed by copyright law to just modify pictures as you want to. This modification, this alteration is also covered within the other directive, but it's there is no explicit inclusion of an adaptation or an alteration right, but the directive just talks about reproduction, but it's common ground that this reproduction right somehow covers the alteration right, because reproduction is, when you think about it, is nothing else but an alteration is nothing else but an altered reproduction of something. So this is covered, and I promise you, when you go back to your national law, you will have different and concrete alteration and reproduction rights within your law. There is something in UK law, we have that in German law, I know that for Portuguese law, so all these national laws implemented this directive, implemented both rights from this directive, even if it's not explicitly included. So these were the basics of copyright regarding digital preservation.